A very good evening, everyone. A quick audio check. Audible, visible to everybody. Please use the chat box. Today we are here to analyze this new bill which has been tabled last week. Thank everyone. So let me just get an audio visual check first and then we begin with the session. Okay, so those of you here, I'm sure all of you are, incredibly inquisitive as to learn as to what is there in this bill. So this session, we are going to understand not only the provisions of this bill, but what has led to this bill coming into place right now. Why is it that it's being tabled at this point in time? And, what exactly this bill pertains to, right? So that is what we are going to be doing in this session. I think we can continue because I believe that I'm audible and visible right now. Let's begin then. Okay. So first and the foremost thing, let's just have a clear overview of what this bill is about to start with. And then we will understand what are we exactly going to be doing or covering in this session today, right? So the bill which is going to be discussed today is your Chief Election Commissioner and other commissioners, appointment, conditions of service, and terms of office, right? So basically, you are talking about how the Chief Election Commissioner and other election commissioners are going to be appointed. What are the methods of appointment? What are the conditions of their service? And what is going to be the term of their office, right? So how long they are going to be being in office, which is the term of their office. Now, this bill was introduced in the Rajya Sabha last week, just in fact, won't even call it last week, it's just 4 days ago. So it was on the 10th of August, 2023, that this bill has been introduced. It was introduced by the Union Minister of Law and Justice, Arjun Ram Meghwal. That was the person who had introduced the bill. What does it provide? It specifically deals with chief election commissioners and election commissioners, right? So that is something which we are going to do in detail as to what exactly are these posts, how are they created, what are the functions that they would be undertaking. So we will discuss all that, right? So another thing which is there so far as this bill is concerned is that it seeks to repeal. Now, so far as the conditions of service is concerned, there is a pre-existing law. This is the Election Commission Conditions of Service of Election Commissioners and Transaction of Business Act 1991. Right now, appointment is something which never saw an act. There was no act which provided for the appointment of chief election commissioners. In fact, that is what you would realize towards the end of this entire session today, is that this is the main thing which is an issue here, right? Now, there were laws in which were in place providing for conditions of service, but so far as appointment of the election commissioner is concerned, there is no law in place as of now. In fact, that is the reason why the Supreme Court in March this year, 2nd March 2023, in the case of Anup Baranwal versus Union of India, the Supreme Court actually came up with guidelines as to how the election commissioners, including the chief election commissioner, are supposed to be appointed. Now, till date, they were always being appointed by the president and on the advice of the prime minister, right? So here, this is the first time wherein, in this particular judgment, the Supreme Court said that no, this is something when you are just, the election commissioner is appointed on the basis of the recommendation of the prime minister. This would not be a very fair way of appointing the chief election commissioner or the election commissioners, right? So they have come up with a set of collegium sort of a thing, wherein they decided that, okay, these are the people who are going to help in the appointment of the chief election commissioner and the election commissioners, right? So in today's session, we are going to do in detail the provisions regarding CECs and election commissioners in the Constitution, So we would understand, first of all, what is it that this bill is trying to change. So the present situation, as per the constitution, as per the Anup Baranwal judgment, what is it like? So the first thing that we're going to do today is we're going to understand the provisions relating to chief election commissioners under the constitution. Then we will have an analysis of this Anup Baranwal judgment. And thereafter, we will then come up to this exact bill. What is it that it is trying to change? What is provided in this bill? What is it that remains the same? Right? Because not everything has been changed under this bill. There are things which are changed. There are things which are going to remain constant, right? So let's go ahead and start with the first thing, that is the constitution. Now, when you look at the constitution, you have part 3 of the constitution, which contains provisions regarding elections. So here, when you look at the provisions regarding elections, these are detailed provisions regarding how elections are supposed to be how elections are supposed to take place in our country. Not only that, it even, when you talk about your right to vote. Now, right to vote is a right provided under Part 15 of the Constitution. That is why, there are a lot of controversy. Sometimes I get a lot of questions from students saying that, ma'am, is right to vote a fundamental right or is it not a fundamental right? Well, if you look at the Constitution, right to vote is not under the chapter of fundamental rights. Rather, it is under the chapter of elections. That is why, technically, when we say what is right to vote is a constitutional right. It is a right given to you under the Constitution, but it is not within the chapter of fundamental rights. So there's a difference between fundamental rights and constitutional rights, right? So when you're talking about, in fact, a fundamental right is given to you under the Constitution. So it is a constitutional right also, but the other way around is not always correct. Okay. Now, so far as the Election Commission is concerned, now Election Commission is a constitutional body. Now, when you look at the Constitution, there are certain entities, certain bodies which are created by the Constitution itself. Now, one of such bodies is your Election Commission. So Article 324 of the Constitution provides for the creation of the Election Commission of India. Now, always remember, whenever we are talking about constitutional bodies, Election Commission is an example. Otherwise, when you talk of the High Court, the Supreme Court, the President, the Prime Minister, Vice President, all these are also constitutional bodies. Why? Because they are creation of the Constitution. Okay. Likewise, so far as elections are concerned, we have the Election Commission of India. Now, what is it that the Election Commission of India is supposed to do? It is provided within Article 324 itself. It says that it provides for the superintendence, control, direction, control, and preparation of electoral rolls, and for conduct of, now this is very, very crucial, that when you are looking at the Election Commission of India, what kind of elections do they superintend, control, and direct? That is going to be your elections, all elections to the parliament, all elections to the legislature of every state, and elections to the president and vice president. So when you're looking at the Election Commission of India, Election Commission of India is looking at the election of parliament, state legislatures, president and vice president. So these 4 are the areas which the Election Commission of India is governing. Now, next, when we move on, who are the members? Now, all this, I repeat again, is provided under Article 324 itself. Now, it also provides as to who would be the members of the Election Commission. Now, it says that there would be one Chief Election Commissioner. So there's one Chief Election Commissioner, and there are such other number of election commissioners as the president deems fit, right? So there is no fixed number of election commissioners that, okay, these are the X number of election commissioners which need to be there. There's no fixed number as per the requirements as desired by the president. This number could change. Today, as of now, we have 3 election commissioners, right? So we have one Chief Election Commissioner and we have 2 election commissioners in place, right? So right now the number is 3, but this number is not a fixed number. It could be changed. Another thing, important thing here is that about the appointment. Now it says if the appointment of the Chief Election Commissioner. Now, this is the main thing which has led to this particular bill coming into existence and the entire controversy around the election commission. All this is because of this concept of appointment. Now, what the constitution provided was that the Chief Election Commissioner and election commissioners shall, subject to the provisions of any law made in that behalf by the parliament, be made by the president. So if you look at the way the article is framed regarding appointment, it was, now, the Supreme Court also in the Anup Banerwal judgment had said that it is subject to law made by the parliament. So there should have been a law regarding appointment of election commissioners in place, and as per the law, the appointment should be made. But since the time the constitution has come into existence, no law has been made regarding appointment of chief election commissioner or any of the election commissioners. There is a law, like we discussed in the previous slide, regarding conditions of service. But so far as appointment of this particular post is concerned, there is no law in place. The appointment till date has been made by the president on the advice of the prime minister. Right now, this is something which has been going on, because of which that Anup Banerwal judgment had come into place. So we'll discuss that in a bit, but let's just first finish the constitutional provisions. Now, the next thing what 324 provides you is the removal procedure. Now, removal here we are discussing, apart from removal also, if the election commissioners want to resign, they always have the right to do so. But when it comes down to removal of the chief election commissioner, he is supposed to be removed on the same lines as the judge of the Supreme Court. So when you're looking at the removal of a Supreme Court judge, that is through the procedure of impeachment. This impeachment procedure is provided within the Constitution itself, right? So the way a Supreme Court judge can be removed, same is the method of removal of the Chief Election Commissioner. But this is only with respect to Chief Election Commissioner, because the Constitution itself provides that so far as the other election commissioner are concerned, they would be removed from office except on the recommendation of Chief Election Commissioner. That means so far as removal is concerned, there is a separate procedure for Chief Election Commissioner's removal, whereas there is a distinct procedure for the other election commissioners, right? The appointment process might be the same, but for the removal, there is a distinction which has been created between the two posts. Now, next, when we look at is Article 324. Now, 324 provides that subject to the provisions of any law made by the Parliament, conditions of service and tenure shall be as fixed by the president, right? So here, whatever, when you talk about the tenure or when you talk about the way, the conditions of service, all that is going to be determined by the president of India, right? So it is the president who's supposed to determine. The only thing, a safeguard which has been kept in the Constitution is that they say that the conditions of service shall not be varied to the disadvantage after his appointment. So this is a safeguard which has been added, right? A safeguard which says that, yes, once you've been appointed, whatever are the service conditions, it will not be for your disadvantage. It will not be changed or varied for your disadvantage, which means that, let's say, if 1990, a person has been appointed, then in that case, in 1992, if you are varying his service conditions cannot be varied to his disadvantage. Let's say in 1990, he was drawing a housing allowance of, let's say, 50,000. Okay, so there's this housing allowance which was being given to him at 50,000. 1992, the government decides to change it and make it 40,000. Now, this is something which cannot be done, because here the service conditions are being varied to his disadvantage. On the other hand, they can always be varied to his advantage. So instead of 50,000, it could become 60,000. So where it is for his advantage, this is valid. Where it is for a disadvantage, it is not going to be valid, right? So this is the basic law regarding election commissioners under the Constitution. Now let's move on to what happened in the Supreme Court, right? So in that Anup Banerwal judgment, what did the Supreme Court actually do? Now, when you look at this judgment was basically given by a constitutional bench. So there were 5 judges who sat together and gave this judgment. It was led by Justice K.M. Joseph, and the other judges were Justice Ajay Rastogi, Justice Anuradha Bose, Justice Rishikesh Roy, and Justice C.T. Ravi Kumar. So there were these 5 judges who sat together and gave this judgment. And mind you, this was a unanimous decision, right? So there were no dissenting opinions. This was a completely unanimous decision, right? So when you look at this judgment, this was given in a PIL which was filed. So there's a PIL which was filed by Mr. Anup Baranwal, who had said that, this entire process wherein the election commissioners are appointed by the Prime Minister himself, by the executive himself, this should be changed. This would not lead to a very, very independent or a fair sort of an election procedure, right? So that was the main issue. So addressing that issue, the Supreme Court agreed, and the ruling which they gave was, they said that there should be a committee comprising of the Prime Minister, the leader of opposition in Lok Sabha, and the Chief Justice of India. So this committee here would be responsible for the appointment of the Chief Election Commissioner and the election commissioners. So for the appointment of CEC and ECs, they said that the Prime Minister, leader of opposition in Lok Sabha, and the Chief Justice of India, they would be the one who would be appointing them. And till when? Until a relevant law is enacted by the Parliament. Now, this was the main basis of this entire judgment. That when you look at Article 324, Article 324 lays emphasis on the fact that when it comes down to the appointment had to be done as per a law laid down by the Parliament. Now, since that law was not laid down by the Parliament, therefore, it was essential that there should be some sort of a committee, some sort of a collegium which is appointing, and not just the executive who is appointing, right? So prior to the day when this judgment was given in March 2023, all the appointments have been made by the President on the aid and advice of the Prime Minister, right? So this is what was set to be changed. Now, when you look at the basis, or what were the grounds on the basis of which the judgment was given, there are a couple of things that you keep in mind. Now, what did the Supreme Court keep in mind? The Supreme Court took into consideration the Constituent Assembly debates of 1949. That when the Constitution was being made, what was the intent of the constitutional makers? Now, so the intent here, it says what was being pointed from the constitutional debates was that the election machinery should be out of the control of the executive government, right? So, a lot of times when you have to interpret a law, especially when it comes down to interpretation of the Constitution, a lot of stress is laid on the Constituent Assembly debates. If you read various judgments given by the Supreme Court, you would realize whenever there is a interpretation of Constitution which comes into place, you refer back to the Constituent Assembly debates to understand that what was the initial intention, what did they really have in mind. So here, when they look back, they realize that what was in their mind was that there should be the election machinery should not be in the control of the government, right? So they said that, of course, the framers of the Constitution left the creation of the exact mechanism to the discretion of the Parliament, that the Parliament is going to make a law regarding the appointment of the election commissioners. And that's where the Supreme Court said that this intent of the Constituent Assembly was never put into action. So in all these years, since 1950, there was never any law which governed the appointment of CEC or ECs, right? That is why they felt that there was a vacuum, and there was a need for the Supreme Court to make some sort of a law on that, right? So that was one of the grounds. Next, when you look at is in the judgment, when they were giving various reasons, the judgment also provides you, a kind of a comparative chart as to there's so many other state institutions, constitutional institutions, state institutions, wherein their bodies, their constituent bodies, appointments are happening. So what are the basis for their appointments? Are they appointed merely on the recommendation of the president? No. So everywhere it was realized by the Supreme Court that there's an independent mechanism for the appointment of the heads and its members. There would always be some sort of a committee, some sort of a collegium, it will be a mixed group of people who would be appointing the head of a particular institution. Like, for example, the one which they have actually imbibed in this particular case is the selection of the CBI director. So in the selection of the CBI director also, there are three people who are involved. First is the Prime Minister, second is your leader of opposition, and third is your CGI. So exactly on these same lines, they have decided, and they have said that these three, till the time there is no law in place, these three would be the selection committee who is going to who's going to ensure that the appointment of the election commissioners are free and fair and free, right? So that is outside the influence of the executive. So it's actually similar to the appointment of the CBI director. Now, next, when you look at the other argument which was given by the Supreme Court was that, they always felt that ECI should be independent, fair and follow the rule of law and the principle of equality. Now, if it is going to be the executive which is involved, or which is going to be solely responsible for the appointment of the chief election commissioner, this is something which could be compromised, right? So therefore, there was a need for objective selection of ECI to ensure transparency and accountability. Now, that's another reason they said that, yes, we should have an independent appointment and not just by the executive. Right. Now, another thing. Now, this was not something which was the binding part of the judgment, but this is an observation which was made by the Supreme Court. Now, the binding part was this, when they said that these three, the Prime Minister, the Leader of Opposition, and the Chief Justice of India, till the time there is no other law in place made by the Parliament, they are the ones who are going to be appointing the Chief Election Commissioner or the Election Commissioners of India. However, there's another observation which is not binding in nature. Now, that was about the removal. Now, as we discussed earlier, the Constitution provides that so far as the Chief Election Commissioner is concerned, his removal will be like the judge of a Supreme Court. But so far as the others are concerned, such rule would not exist. So the Supreme Court also observed that it was desirable that if, so far as the other election commissions are also concerned, there should be sort of an independent manner, similar like the Chief Election Commissioner, so that there is no kind of influence. Now, right now, the rule says that whenever there is a recommendation by Chief Election Commissioner, then there can be a removal of an election commissioner. So this would still not be, the Supreme Court was of the opinion that this still does not give independence to the election commissioners. You should have a similar rule like it is for the Chief Election Commissioner. So this was just a recommendation, just an observation by the Supreme Court, not something which is binding in nature, right? Only the binding part was the appointment bit. Okay. Now, this was so far as the judgment is concerned. Now let's move on to the actual bill and see what all was kept, what all was not kept, and what all are things which are in controversy, right? So the bill here, if you look at it, is it's talking about the appointment again by the president as per 324. Now here, like the Supreme Court, they also came up with a selection committee. Now, but the selection committee here, the composition is completely different. You have the Prime Minister, who's the chairperson, perfectly fine. Then there is also the leader of opposition in Lok Sabha, okay? But the third member, instead of the CGI, so they took CGI out of here, the Chief Justice of India has been removed from here. Instead, there is the Union Cabinet Minister nominated by the Prime Minister. Now, this is what has led to the entire controversy over the bill. That end of the day, you are saying that you are bringing a law, you are bringing a bill in order to ensure that there is, transparency in appointment. But in effect, if you look at the three people who are going to be responsible for the appointment, one is the Prime Minister, And there's one more who's a union cabinet minister, again appointed by the prime minister. And obviously the decisions are going to be taken by a majority, right? So therefore, this is something which has come into, has led to a lot of hue and cry by the opposition. Okay, so another thing to be kept in mind though here is when you're looking at the leader of opposition in Lok Sabha, now if there is no leader of opposition, then the bill says that the leader of the single largest opposition party in Lok Sabha will assume the rule, right? So either of that is going to be there. Now, okay, now one thing that they have come up with is the selection committee. The next thing which the bill provides is the concept of a search committee. Now, this is also something which is new. Now, what does the search committee do? Now, search committee is going to prepare a panel of 5 persons who are going to be considered by the selection committee. So once the search committee prepares a list of 5 people, out of these 5 people, the selection committee is going to make a choice. Now, who does the search committee comprise of? It is supposed to be headed by a cabinet secretary and 2 other members not below the rank of secretary to the central government, right? And there is a need and requirement for knowledge and experience. So you're supposed to have knowledge, experience in matters relating to election, right? So this is going to be so these 3 members are going to be the search committee who are going to decide 5 members out of which the selection committee is going to select. Now, the only hitch in this is also that the bill also says that the selection committee may also consider candidates who have not been included in the panels prepared by the search committee. So, in effect, the search committee is fine. The 5 people search committee provides you is okay, but the selection committee has been given this additional power that if they want, they can appoint somebody who's not even a part of this search committee, right? So this is another, drawback or another controversial thing about this bill, that even though you're talking about a search committee, but you're giving sort of an overreaching power to the selection committee, wherein even though 5 people might have been selected, selection committee can still go on and, appoint somebody who's not even part of that panel, right? So that's something which is, again, a controversial point. Now, the other new thing which is there provided in this bill is qualifications of CEC and ECs. Now, this is the first time that such a qualification rule has come into existence. Till now, there was never any kind of qualification which is needed for being appointed as the CEC and EC, right? So there was no rule prescribing qualifications till now. Now there is a rule. It says that persons who are holding or having held post equivalent to the rank of a secretary to the central government, right? And they're supposed to have expertise in managing and conducting elections, right? So this is a basic requirement if you want to be appointed as a CEC or a EC, right? So this is something, again, something new, not anywhere before this bill. So in fact, all these 3, the selection committee, the search committee, the qualifications, all this is something which is very, very new. Now, the next thing which is there so far as this law is concerned, bill is concerned, it says that the, once the selection committee has decided, the selection committee will appoint the CEC and ECs, right? Just a second. So they are the ones who are going to appoint the CEC and EC. This is perfectly fine. Now, the next thing is, apart from appointment, what is the other thing that this bill does? Is talking about the conditions of service and terms of office. So when you look at the conditions of service, now it was the 1991 Act which used to provide the conditions of service. Now that Act is going to be repealed as and when this bill comes into existence, it becomes an act. Now, here the difference, generally, whatever the provisions of the 1991 Act, more or less the same provisions are being repeated in this new bill also. But there are certain things which are different, and one of those things which is different is when you talk about the salary of the election commissioners. Now, earlier under the 1991 Act, the salaries of the election commissioners were supposed to be equal to the Supreme Court judge. So whatever is the Supreme Court judge's salary, it was supposed to be equal to that. But now that has been changed, and the bill provides that the salary, allowance, and service conditions of CEC and ECs will be the same as the cabinet secretary. So in effect, there is this another grouse, another complaint that by doing this, what are you doing? You are kind of, lowering from the status of being equivalent to a Supreme Court judge. You are now little lower in the hierarchy and becoming equivalent to a cabinet secretary. Though, there is this argument that the amount of money that you would be getting monetarily, there is no difference. Monetarily, it is the same. But yes, otherwise, when you look at the hierarchy and you look at the, the hierarchy as to where you stand, there is a coming down so far as the election commissioners are concerned under this particular bill. Okay. Now, the next thing which is repeated, which was there in the earlier law also, that is your term. Now, the term was always 6 years or until you reach the age of 65 years, whichever is earlier. The same thing which is there in the 1991 Act is also there in the present Act. However, there's one thing which has changed, and that is that there cannot be a reappointment. Right? So the reappointment, they are not eligible for reappointment is something which is there in this bill. Right? So the bill provides that 6 years terms and also became the CEC. So that would not mean that, let's say you've been election commissioner for 2 years and then you become the CEC. So as a CEC, you're only going to have a tenure of 4 years, because in total, you cannot have a term which exceeds 6 years, right? So 6 years is the upper limit or your age, 65 years of age. And another thing which is important, there is no reappointment which is possible. So once you've been the election commissioner of India, you thereafter, there's nothing you cannot become the election commissioner again, right? So there's a bar on reappointment. Now, another thing here is when you talk of removal from office. Now, removal from office, like I said, the same provision as under Article 324, the same is going to apply, that CEC can only be removed in a manner similar to a Supreme Court judge. That is your impeachment process. Now, what is the impeachment process? Impeachment process is basically when it's an order passed by the president. What is it based on? So basically, there's a motion which is moved in both the houses of parliament. Right? So both the Lok Sabha, Rajya Sabha, in the same session, there is a motion which has to be passed. And after this motion is passed, which, which calls for the removal, that is when you can have the removal of the Chief Election Commissioner, not otherwise. And so far as the other election commissioners are concerned, the same thing which was there earlier remains, that they can only be removed from office on the recommendation of the CEC. So basically, the observation or what the Supreme Court had recommended on this part has also been not taken into consideration, right? So they have not taken into consideration that they should also be some sort of an independent, removal method for the other election commissioners also. Whatever was the earlier position, that is what remains till now. Okay? So the Supreme Court recommendation not taken on this as well, right? Chalo. Now this is so far as the the terms or the important parts of the bill are concerned. Now, next thing which we are going to do is we are going to discuss what are the grounds of opposition. Because this entire bill, we see a lot of controversy. I'm sure all of you have read a lot of articles on how this bill is trying to do exactly the opposite of what the Supreme Court did. So in effect, what is the government trying to do by the bill? The government is replacing the Chief Justice of India with a nominated cabinet minister, right? So here what you are saying that in effect, you're trying to ensure that the executive's dominance is still there in the appointment. Right? So therefore, the people who are opposing this particular bill are saying that this is undermining the independence of the election commissioner. So even though there is a bill which is being brought about, even though you're bringing a law in place which is going to oversee the appointment of the election commissioner, but in effect the situation will still remain the same. So because even prior to this bill, prior to the Anup Baranwal judgment, the position was that the Prime Minister was the one who was calling the shots so far as appointment is concerned. And even now, with this bill coming into place, again, it is the Prime Minister who's calling the shots, because it is the Prime Minister who's going to nominate the third member of the selection committee, right? So therefore, it kind of, is an eyewash so far as bringing the bill is concerned for so-called transparency, right? So that is the entire basic controversy regarding this particular bill. Another thing which is there is when you look at the search committee. Now, it only provides that there would be a search committee, but it does not provide you an effective means as to what would be the basis of selecting those 5 suitable candidates, so-called 5 candidates. Now, there is nothing provided in the act as to what is going to be the basis of selecting those 5 candidates. Again, a lot of discretion is left with the government, with the search committee here. Now, another thing is when you look at the selections committee's power to choose, this is something we just discussed also. Now, this is, so in effect, even though you have a search committee in place to make these recommendations, firstly, these recommendations itself do not, the law does not provide any basis for them. There is nothing provided in the bill as to how they are going to be selected. On top of that, the selection committee can overlook whatever the search committee is giving, right? So that is something which is again a point of controversy, that there is no point. They're completely undermining the purpose of shortlisting, right? So the shortlisting process is completely of no relevance. The next thing is the rank of election commissioner is being reduced. Now, in a government service, there's always this warrant of precedence as to who is going to be considered the highest in hierarchy. Like when you talk about the head of the state is going to be the president, right? So thereafter, there's a hierarchy. So when you are saying that the conditions of service of an election commissioner will be like that of a cabinet secretary, you are in effect reducing his order of precedence, his warrant of precedence. So here, hierarchy wise, he is going down, right? So that is something which is again not really not really in favor of having an independent sort of system of elections. You would want the election commissioner to be more powerful rather than reducing his power, right? That's what this bill is trying to do. And the last thing is about the removal of commissioners. Again, whatever was the recommendation of the Supreme Court, that recommendation has not been taken up by the bill, right? It is still sticking to what was there in the previous act, in the previous system, wherein so far as the chief election commissioner is concerned, it is going to be the removal process just like Supreme Court judges. But so far as the others are concerned, it is the discretion of the chief election commissioner, right? So the independence of the other election commissioners kind of compromised there, right? And nothing to that effect has been catered for by this bill, right? So that is the basic controversy behind the entire bill. Now, keep in mind that another thing which is very important so far as this bill is concerned is that the timing. It was in March 2023 that the judgment came in, and within months of this, in August 2023, we have a bill opposing it. What's the hurry? We have our Lok Sabha elections coming up in April, tentatively April 24. And if you look at the practical scenario, the 3 election commissioners that we have, 2 election commissioners and 1 CEC, one of these election commissioners, you have Mr. Anup Chandra Pandey. This election commissioner is retiring somewhere in Feb 24, just prior to the Lok Sabha elections. Hence, the timing of this entire activity also is something which is under question, right? So let's see how things pan out. Right now, this is in the form of a bill. It has just been tabled in the Rajya Sabha. We still have a lot of time to see what happens to the bill. But yes, there's something which is very new. There is a judgment in place. There is a bill in place. So again, so far as your CLAT is concerned, your exam is concerned, this becomes one of the hot contemporary topics on which you can have a passage, right? So my recommendation to you guys would be read about it. have a clarity, have an understanding, a little bit of the history. When you look at today, I'm taking it more from the perspective of legal reasoning, that how, you could have questions on this, but there could always, this is a very, very important topic so far as your GK is also concerned, because when it comes down to GK in CLAT, it is supposed to be, you not only have current, but static related to current, right? So again, a lot of constitution comes into play here, a lot of, old laws come into play here. So please keep those in mind and keep up with your prep, right? So this was so far as this particular bill is concerned. If you have any kind of feedback, any new information you need on this bill, please feel free to leave your comments. I would come back and answer your questions wherever there is any need. And do stay tuned to the CLAT Possible channel. Here on the screen are our various social media handles, our platforms. You can always get in touch with us if you need any kind of help with your CLAT preparation, right? So signing off, I'm Neha, and best of luck with your CLAT preparation. Take care, guys, and stay safe. Study hard.